as soon as reasonably possible, but not later than 24 hours after being arrested. 2, if the 24 hours end outside ordinary court hours on a day that is not an ordinary court day, the end of the next court day. Now, 1G, at the first court appearance, to be charged or informed of the reason for the detention, continuing, or to be released. And H, to be released on bond or bail on reasonable conditions, pending a charge or trial, unless there are compelling reasons not to be released. The thesis being pursued by the applicant is that the continued detention of the respondents will assist them finalize their investigations. The respondents, on the other hand, see no basis for their continued detention. The first respondent is categorical that there are no compelling reasons for him to be further detained. The second respondent points out that the only mention about him has to do with a firearm which he is licensed to hold. The respondents have separately stated that they presented themselves to court, to the police station, and that the police can do their investigations without them being in custody, as they cannot interfere with those investigations. I've had an opportunity to read 2 High Court decisions of this matter. The first one, every case must be looked at on its own merits, while the liberty of the suspect should not be deprived. On a case-to-case basis, police need time to do proper investigations. The offense contemplated in this miscellaneous matter is murder, which is a serious offense. A precious life was lost that cannot be wished away. Ultimately, the victim and his family, as well as the respondents, would want to know exactly what happened. The applicant has indicated in the affidavit that he intends to do what he intends to do in the investigations. The respondents have insisted that they showed good faith by presenting themselves to the police. While that should be lauded and could be a bonus should they formally be charged, investigation should be done by the police. The second respondent points out that his link with this case is limited to the firearm which he lawfully held. That the police have not taken statements from key witnesses is material, while the respondents show clean hands to this court. The temptation to interfere with potential witnesses cannot be wished away. The police have done their cardinal duty to present the respondents to court within the required time. The circumstances of this case are clear, that the police need more time. If no sufficient evidence is gathered, the respondents will be discharged. In the upshot, therefore, I find that the applicant has made out a case for further detention of the respondents, and I order and direct that the respondents be detained for 12 days, and that will be effective 23rd of August this year. There will be no orders to costs, and this matter will be mentioned on the 4th of September this year, so that the court can be told about the progress of the case. That's the ruling of the court. Unless there's any other application, I will be making further directions that a certified copy of the ruling be supplied to all parties involved upon payment of requisite charges.